Morning, everyone. We are having the second of the workshops in the Flying Research Kite series, and Professor Mustafa would be talking with us on the whole issue of new frontiers in constitutional law research. As I had mentioned to you yesterday, largely what we are trying to do with this series is that we are getting experts in the field in a way to speak of their own wish list, areas in which research should be done, because everybody can't do everything. So it's a way of creating a, you could say, a collegial kind of affinity between younger scholars and senior scholars, where senior scholars can be lending direction in which what all you can be doing. Sometimes very niche areas or very core areas on which you can work, it takes you a long time finding them. So this is supposed to be assisting you in working out okay, this is an area, this is a potential area in which work can be done. I am not going to be presumptuous enough as to introduce Professor Mustafa. I'm just going to welcome him to his own university and say that, okay, Professor Mustafa, your show from here.
शो पतंग उड़वा रही हैं आप हमसे बुढ़ापे में.
खुद आपसे बड़ी हूँ, उड़ा रही हूँ.
So good morning and thank you, Professor Dhanda, for giving me this opportunity to share my thoughts about frontiers in constitutional law researches. Let me first make some opening statements because it's a long conversation we are going to have today, and I am not as gifted and as knowledgeable as Professor Dhanda that I can engage you for hours together. So let me first of all tell you that I really didn't like this book by Sanjay Baru, which was written with all political motives in 2014 prior to general elections, called Accidental Prime Minister Making and Unmaking of Manmohan Singh. Of course, there is a breach of privilege of number of privileged communications, and that's not good for a senior journalist who was the head of Prime Minister's media office. But there is a similarity with the title of the book and my association with constitutional law. So in Aligarh, we had as many as 5 full professors of constitutional law, all of them scholars in their own right. Some of them did not write too much, but they were excellent classroom teachers. My own constitutional law teacher, Professor Virendra Singh Rekhi, who came from Lucknow and then spent rest of his life in Aligarh prior to his going to Bhopal as the founder vice chancellor of National Law Institute University NLIU Bhopal, taught me constitutional law, and whatever little constitutional law I know, I owe it to him. But the point I'm trying to make is that 3 professors retired, one after another, and 2 professors died, and 2 more people were teaching, but they went abroad, who were not professors, but fairly senior teachers of constitutional law. And then the head went round to everyone, asking people that you volunteer to teach constitutional law. And since no one obliged him, and I was the junior most teacher at that point of time, he came to me and did not give me any choice. I could not refuse. And that's how I started my constitutional law teaching. In the process, I had to leave my intellectual property law field. So what I'm trying to say that I have not done any research myself in the field of constitutional law. I am an accidental constitutional law teacher, and I am not a scholar of constitutional law. Yet, I think this whole flying research kites initiative of Professor Dhanda, uh, I want you to tell that what I could not do, you are better placed and you are more competent to do those kind of researches. So I have all this frustration that these are the areas in my mind in which researches are to be done, but I myself could not do. And the other thing is that with this administrative responsibilities, which is absolutely a thankless job, there is hardly any time for me for hardcore academic work. So what you are hearing from me is not from an expert of constitutional law, but someone who was a student and then was asked to teach. So I think I wanted to tell you that maybe things I am saying may not be really correct. Now, the other point I want to make that constitutions are all about democracies. So if you do not have democracy, there is not much need to talk of the constitution. I am reminded of J.S. Mill's statement, which was subsequently quoted appropriately by Dr. Ambedkar a day before our constitution was adopted. That is 25th of November 1949. The constitution was adopted next day. And I think this statement of Mill has lot of relevance. And the statement itself not only can help us in developing, which I am going to very strongly advocate today, some kind of constitutional culture in the country, but also this gives us ideas of some kind of areas of research. This is what Mill said. We must observe the caution. No, sorry. This is what Mill said, that all who are interested in the maintenance of democracy, namely not to lay their liberties at the feet of even a great man, or to trust him with powers which enable him to subvert their institutions. So in constitutional law or in any democracy, there is no place of hero worship. If you want to do worship, freedom of religion allows you to worship any god of your choice. And fortunately in India, we have many, many gods. So you have all the choice. You can pick up any one of the god of your choice and do all 24 hours bhakti if you want to do that bhakti, or if you want to pray all 24 hours your namaz, do it. If you want to fast not 1 month in Ramadan but in the entire year, do it. I know some people, some of my neighbors, one elderly woman in Muradabad used to fight all days in a year except the 4 days of Eid where you are prohibited to fast. So for a democracy and a constitutional system, there is no place like this statement, India is Indra and Indra is India. Similarly, Modi hai to mumkin hai. I think that kind of a statement doesn't go well with a constitutional system. Similarly, I believe that there is much to learn and understand from Dupont de Nemor's statement. The laws of the state should be no more than acts acknowledging the essential laws of social order. We have not been paying much attention on the laws of social order. the positive legislation. Yesterday, Professor Dhanda was referring to positivism. So positive legislations are important. And as administrator, both Professor Dhanda and me realize that there is much truth in Austin and Bentham's theories. But then after all these positive legislations which emanate from the state must be and should be subordinated to law of society. And therefore, for any researcher in law, I think the first endeavor has to be to find out law of the society, if there is any. And if there is no law in the society or no law of the society, then we need to bother about it, think of it, and find reasons why our society is so. Now, the third opening statement which I want to make this morning is that we may look at law as a practical discipline, and I am going to tell you in a minute that since law schools think so, that their primary job is to provide professional lawyers. Of course, some of us have been saying we are providing and producing, competent lawyers and ethical lawyers and those committed to social justice, socially relevant lawyers, all big words we have been using. But most of our students, as you know, they have been going to corporates, earning big money. But the problem with all NLUs is this, that since we are largely undergraduate driven institutions, it is BA-LLB course, which is the most prestigious course of national law universities. Accordingly, there is not much focus on research. Secondly, I feel that we have a handicap that we do not have experts of humanities and other disciplines in national law universities. You will have some junior teachers in history and political science and economics and sociology, and your students will invariably would find it difficult to do maths, and therefore the economics teachers are to be replaced several times. But since we do not have full professors in other disciplines as traditional multi-faculty universities would have, national law universities do not have a great record of legal research, including constitutional law researches, because our teachers are too busy with the evaluation of mid-semester sessionals and projects. We have very few teachers available. There are many national law universities who do not have even a single full professor. Some of them will, just manage with some retired professors. But otherwise, if you look at people who are full-time researchers or doing great researches, I think we have an acute paucity of human resource in NLUs, and we are handicapped because we do not have many people from humanities and social sciences. And it was to keep this in mind that Nalsar took a decision that we would recruit full-time assistant professors, research, associate professors for research, and full professors for research who will largely do the research. Of course, in their research areas, they may also offer some electives and seminar courses. But the whole idea is that since we are a small university, and unless we have a dedicated faculty for research, we can really not make much inroads. Now, we at Nalsar, both me and Professor Dhanda and Vasanti is also here, we feel that it is not enough and it is not right to look at law as just a practical professional discipline. We must look at law as a subject of humanities, as an essential discipline of social sciences. And if this is so, then mere interdisciplinary research is not our goal. We rather want to create new disciplinary synthesis. And if we can create those syntheses, I think this kind of workshop, which Professor Dhanda is organizing, would be really useful. As we no more think of law, as I said, as a profession and a practice, but consider law as an integral part of liberal arts. And since we are treating law as liberal arts, we are proposing different thrust areas of research for Nalsar. Now, I would also like to say here, since I teach law and religion, so I'm borrowing this example from law and religion, that it may really be a time for the humanists, for those who are the experts of humanities and experts of social sciences, to do for law what study of religions has done to theology. Let me elaborate. Until recently, religion had a different kind of connotation. The researches in religions were of different kind. Then people started studying religion. And this studying religion has changed theology. I give you an example from Aligarh. So you have a whole faculty of Sunni theology and you have a whole faculty of Shia theology. And I don't have any disrespect for either of these faculties. But the moment Department of Islamic Studies was established, most people got attracted to Islamic studies because it was looking at Islam as a discipline and it was not looking at as something divine. And as a result, things have started changing, and the kind of researches which Department of Islamic Studies has done are entirely different from the kinds of researches which these two theology faculties have been doing for over 100 years. I'm reminded of a conversation I had with my mother many years ago when I started reading F.E. Peters' History of God. She was really very, very offended. And she said, "What is this nonsense? It is blasphemous. History means God is dead. And you are, studying this book, History of God." But believe me, when I, after reading the book, told her that this is not talking of God is dead. F.E. Peters is saying over different civilizations, what was the conception of God? So how people thought of God. This is what the book is all about. So I feel that what study of religion has done to theology, the social science scholars and the humanities experts probably have to do for law. And we are more than willing to have this conversation because we are now going to give a lot of importance to humanities and social sciences at Nalsar. Of course, law schools are not all about, legal research. Law schools have to be the centers of research. They have to create knowledge. To be a university, you have to bring the universe of knowledge. The new education policy now very clearly says that after 2030, they will not permit any single discipline university. And therefore, we need to have more disciplines within the premises of national law universities to survive beyond 2030. And I believe that this will do some good. So this is what I initially wanted to say. Now, coming to the constitutional law scholarship, since we did not benefit much or did not attach much importance to humanities and social sciences, did not look at law as liberal arts, and therefore our constitutional law scholarship has largely been text centered. So you will have PhDs on right to equality, on personal liberty, on 356, on center state relationship, on president is a nominal head or a real head. You will have something on some PhD on state and Article 12, like this. Those who went beyond text were an improvement on this test centered approach. They were judge centered, and therefore they studied dissenting judgments of the Supreme Court. Some of them also did researches on public interest litigation. With all praises of public interest litigation, I'm going to flag for you another topic of public interest litigation, which is not so much in praise of public interest litigation. I personally feel that public interest litigation has damaged our constitutional and legal system a great deal, but that is little later. So when we are doing the judge-centered research, we may also look at the values of judges, how they determine the reading of the text. But we have not done much in terms of culture-centered constitutional law researches, or society-centered constitutional law researches, or even litigant-centered constitutional law researches. There is hardly anything to mention what matters go to the court, who takes them, why certain matters end up in the court, and why certain matters do not go to the court. If I can be allowed to take examples from United States, how come in the entire 19th century, not a single significant case on freedom of speech and its limits went to the courts? I mean, the Supreme Court of United States. The first decisions on freedom of speech in US will come around First World War. And what were their concerns? Political speech, pamphlet speeches, writings by the anarchists, pacifists, leftists. Similarly, no obscenity case reached the court until after the First World War. Why this silence on these two important topics? I would also like to take the example of rights of prisoners, which is very much a part of constitutional law. Many people think it is part of criminal law, but I think no good research on criminal law is possible without adequate grounding in constitutional law. So until recently, I think, say a century ago or so, there was no field called prisoners' rights. A prisoner was not considered to be someone with which law concerned. He was totally outside the pale of law. Of course, brutality was forbidden, at least in terms of theory. But there are opinions where courts have said that the Bill of Rights did not apply to the prisoners who were considered civilly dead. Or as one US judge in 1871 had put it, slaves of the state. And therefore he forfeited all his rights. An interesting case which we do in law and religion, I would like to mention, 1912 case from Pennsylvania. The question was that one prisoner refused Sunday services. Just 1 minute, sorry. So one prisoner in 1912 in Pennsylvania refused Sunday services. The jailer had ordered him to go, but he preferred to take extra penalties and punishment. He was not interested in this religious prayer. Now today, we would very easily say that what is there in this case? Freedom of religion includes freedom from religion. A prisoner is entitled to follow a religion or not to follow any religion. But 1912, when we are talking of a US, their constitution was in place. The code did not frame the question like this. The personal religious autonomy of a prisoner. They rather said that the jail authorities are like parents. Parents have a right to discipline children. No child will accept it today. Similarly, the prison authorities in this case have a similar right. And then it took many decades. It was in 1960s that it was authoritatively said that other than their right to movement, the prisoners do retain other rights. The point I am trying to draw home from these examples is that what matters go to the court and what matters do not go to the court. What is the role of a litigant has not been researched enough. And I think this is important. I would also like to say yesterday we had some discussion that we need to find answers. I have a slightly different view. I have been thinking over this discussion overnight. I personally feel, and I may be wrong, that a constitutional law researcher, or for that matter, any researcher in law, is not here to make a vaccine for Delta plus variant. They need to find answers. You have a problem, get vaccine. Generally, scientists used to take 7 to 8 years. This was an extraordinary situation. Within a year, they came up with a vaccine. The job of a scientist is to find answer to such issues. For a legal scholar or a constitutional law scholar or for a social science scholar, answer is not the goal, because there may not be any definite answer. We discussed this yesterday. What I was trying to ask Professor Dhanda was this, that my limited experience has been that both refresher courses in universities as well as PhDs, they are not done for the value which they provide. Rather, they are done because UGC mandates that you will not become associate professor if you have not done 2 refresher courses. Similarly, people do PhD not become associate professor, and now they say even assistant professor without PhD. And therefore, I entirely agree with Professor Dhanda that PhD should not be a qualification to enter academia. Most of us first taught for a few years, and then we did our PhD, and I think it is a better thing to do. In any case, once you are enrolled for PhD, take it from me. We will give you a PhD. We will, if anyone who takes admission in BA, LLB or LLM, we don't allow them to go out of our premises without a degree. So we will definitely give you a degree. You will become a doctor. The question is whether you become a useless doctor like me or a useful doctor like Professor Dhanda. And I would very strongly recommend that do researches like Professor Dhanda. So we are not here in constitutional law researches to find answer of X, Y constitutional questions. We are here to discover different approaches to constitution, learning the sources that guide constitutional interpretation. Of course, we will look at the text, look at the intention of the framers of the Constitution, look at the cases, look at the history, economics, and political trends, look at the policy implications. You just saw recently. The government of India did not probably have any cabinet note on the distribution of vaccine, because the order from Chandrachud was that on next date you produce the cabinet note. How you decided it? That same vaccine from same company, the company will sell to the central government at X price and to the state government at Y price. How do you decide which state gets how much vaccine? And therefore, it required none less than the Prime Minister himself to come and address the nation and tell that Central will provide vaccine to everyone. How come in constitutional law researches, in spite of RTI now there for as many as 15 years, we do not do researches based on how government, particularly state governments, make policy decisions? I'm going to talk of one topic where in RTI, someone was able to get a cabinet note. I'm going to tell you that in few minutes. So what I'm trying to say that of course in any research in law, as Professor Dhanda yesterday said, there will be inquiries like why a particular rule, what led to its adoption, what are its effects, whether it is suited for current conditions, can it be further improved, should it be replaced with some other rule. Of course, all this will be done. But we are going to talk to you today of something else, something beyond this. And here I want to refer to Jorgensen, that legal ideas are structurally connected with existing social system. The legal rules of which it is attempted to explain and synthesize in a set of legal ideas and a legal method which is necessarily bound up with the entire word picture of time concerned. The science of comparative law seems to confirm the general experience that societies at same economic and social stage are confronted with same legal problems, which are solved in almost in similar manner. Although there may be differences in legal tradition, in formation of concept, in systematics, etc. But by and large, this is what, that at a given point of time, many societies will have a similar problem and they need to find solutions to this. When I was doing a strict liability, I looked at this problem that both in America as well as in England, the problem of regulatory offenses, post-industrialization, where you wanted to punish people without mens rea, it arose, and both the systems answered it almost in a similar manner. Today, democracies are turning authoritarian. That is the problem of democracy. The foremost problem of democracy is this. And that's why I will very strongly urge you to read this book, How Democracies Die, and also this edited volume, Democracy Under Threat. So many democracies are in problem, including in the Western Hemisphere, including America, and also, of course, in Asia. Today, there is no danger from bullet. The real danger is from ballot. You don't see any more military coup, assassination of presidents, takeover of the state by the military journals, suspension of the constitution, imposition of martial law. That age is gone. Now you have elected autocrats. You have authoritarianism because people elected people they knew were authoritarian. How come the political parties nominate such people? They have been in their party for decades. Why political parties are not able to perform the role of the gatekeepers of the democracy and constitutionalism? Why such people get elected? Why society prefers such people? Manmohan Singh is soft. We don't like him. He doesn't speak. He is Mon Singh. We want a strong prime minister. We want a change. This is a battle cry not only in India but everywhere. Why there is so much of hate in our society? Why it is not a concern of a constitutional law researcher? Does Constitution promote hate? Does Constitution promote authoritarianism? Does Constitution promote that the Prime Minister will not be one amongst equals, but he will be number one and the next man will be at number 101? That was not a cabinet system which British people have evolved and developed. There are no researches whatsoever as to the working of the Prime Minister's office and ministers' offices. I give you a current example. There are 40 to 43 central universities. 50% of them don't have a vice chancellor for a year, year and a half, 17 months, 6 months, 8 months, like this. The search committees had been constituted, positions had been advertised, recommendations had been made to the minister. Under the cabinet system, the minister is supposed to just forward the file to the president, the visitor. But if you look at 3-4 articles which recently appeared in different newspapers and the news portals, it seems there was no clearance from PMO. And after this news, when it was published in number of papers, within a week or so we heard that 12 files have been sent to the president. That means the cabinet ministers do not have a right to decide on their own. How come this is not a subject of constitutional law research? I give you another example. 2019. In Lok Sabha, a question is asked to Social Welfare Minister. Is the government planning to bring in reservation for economically weaker sections of the society? The answer is no. Is there any plan to give such a reservation? Is it under the consideration of the government? The answer is no. And it is part of a public record. 48 hours, both houses of the parliament pass the constitutional amendment. I think there can be any number of topics. around this theme: how democracies are dying, how democracies are turning authoritarian, how much of its blame can be given to the provisions of law, and how much of the blame should be shared by the people or by the society as such. Constitutional interpretation is one of the central topic of interest for any constitutional law researcher. Yes, Constitution has always been and will be read, but it should ideally be read in the light of social and cultural system in which it is embedded. Many of us follow Charles Evans Hughes that the Constitution is what judges say. It is what judges say it is. But as I said before, judges don't have a choice in terms of the kind of cases which will come up before them. I know there are rare exceptions. So MC Mehta knew Kuldeep Singh is more than willing to accept any petition coming from him on environment. And therefore, because of Kuldeep Singh, there was huge increase in matters relating to environment. The judges cannot do what they please. The constitutional system is not at the whims of these 30 plus 3 Supreme Court judges or 9 autocrats in the United States. They work in context. As I said, they don't set their agenda. They take cases which are brought before them. And who decide which cases go? As I said before, litigants. What claims to press? What claims not to press? But this prime mover of our legal system, the litigants, has not been researched enough. Of course, judges are also creatures of a given society. They reflect our attitudes. So how come, even though there have been researches on procedure established by law, and how Supreme Court from Gopalan to Menaka Gandhi brought in the whole due process doctrine, what changed it? We will keep mentioning cases after cases. But constitutional law researchers in law schools, I'm not talking of humanities, do not research this attitude in judges. How come in the Gopalan bench it was only Justice Fazle Ali, but subsequently you had Menaka Gandhi, Bhagwati and all others going to the other extreme? And Bhagwati is an interesting character. In a state of Rajasthan, when 9 democratically elected Congress governments are to be dismissed and 356 is to be used in mass for the first time, the paragraph from Bhagwati's judgment is an interesting reading. Never in the history of this country such an unequivocal rejection of central government has happened. So what? Central government and state governments are not one and same. And then when Mrs. Gandhi came back to power, here is a man writing a letter with all praises of her that now everything will be set right, poverty will be eradicated, poor will get their entitlements. But my question is different. What really changed from Gopalan to Menaka Gandhi? Was it emergency? If it was emergency, and yesterday there was a anniversary of emergency, number of write-ups were written on emergency. Those who are themselves authoritarian are talking of emergency excesses. That looks good and strange. But if it was emergency, how come you got ADM Jabalpur? And if it was emergency and we have learned our lessons, how come when you have an undeclared emergency, our judges are not behaving differently? They are not behaving even in a manner consistent with Menaka Gandhi. CJI Bobde about Kappan's case. Here is a journalist who recently lost his mother as well, going to Hathras to report the rape and killing of a Dalit woman. And you have NSA and sedition and this and that charges. For months together, the habeas corpus petition has not been heard. And Chief Justice Bobde said, you should not come to us under Article 32. So what has changed? Chief Justice Ranjan Gogoi telling a Kashmiri girl, Mehbooba Mufti's daughter, don't go there, it is too cold out there. Day before, the law minister was denied access of Twitter for 1 hour. Read yesterday's any newspaper, it is a front page news. On all news portals, this has been widely reported. People of Kashmir were denied internet for almost 2 years. Number of them have been detained and their habeas corpus petitions have not been heard for months together. And when they were heard, they were adjourned for 1 month, 2 months, 3 months. While the law is, if a habeas corpus petition comes before a judge, he will not hear any other matter without disposing of habeas corpus petition. Why our judges, in spite of experience of emergency, have forgotten this fundamental rule of how to dispose of habeas corpus? There is a research in constitutional law which studied habeas corpus petitions and a decisions on habeas corpus petitions. I think the time has come when we should look not only at the habeas corpus petitions and their decisions. I am saying particularly petitions, because then you will know the litigant with what grievance he has gone to the court. Bail orders. 3 judgments, recent judgments, in 3 cases from Delhi High Court, all based on Supreme Court judgments. The judge has not read down UPA, has not said that any provision of UPA is unconstitutional, is within the framework of UPA, following Supreme Court judgments. And Supreme Court feels the orders are strange. And coming up with a very interesting thing, that it will not act as a precedent in other cases. I have not read jurisprudence, but Professor Dhanda has done it and taught it for years. Either there is a stay of an order or there is no stay. How come the court did not stay the order and yet says it will not operate as a precedent in other cases? And I think for a constitutional law researcher, this will be an interesting topic to research. Look at bail orders of different high courts. And now you can also get on Live Law and several other portals, even bail orders of the sessions courts and lower courts. It is not a topic of just criminal law, it is very much a topic of constitutional law. After all, it is a question of Article 21. I can understand the court not hearing abrogation of 370, its constitutionality. I can understand court not finding time to decide the constitutionality of Citizenship Amendment Act. Fine. Constitutional benches have a waiting time. That's fine. But habeas corpus petitions won't be heard. And decided this way or that way, you reject it. Give an order, reject it. That is fine with me. How come judges in Aadhaar, in privacy, 9 judgment, say all good things, but Aadhaar judgment is a disappointment? The whole privacy judgment came in because of a litigation on Aadhaar. Why this change? Studying judgment has been a topic of research for constitutional law researchers. But how come this change from privacy judgment to Aadhaar, so much so that we have made Rajya Sabha irrelevant? I think another very interesting topic would be, we are going to have 75th Independence Day, or we are creating a huge central vista to celebrate it. Why not look at the utility of Rajya Sabha? Excellent topic to research. What amendments or laws were passed by Lok Sabha when they went to Rajya Sabha? What kind of debates took place? Were they different from Lok Sabha? What changes were suggested by Rajya Sabha? How many of the changes suggested by Rajya Sabha were accepted by Lok Sabha? Is it really elders' house? And if it has no utility, why such a huge burden on the exchequer? Why Rajya Sabha has not emerged as a house of states? Why it is not able to present the views of the state? It is a council of states. It has miserably failed in protecting the interest of the states. Similarly, why change in the judicial attitude in terms of whole question of equality? We did move from formal equality to substantive equality. We did hold that 16.4 is not an exception but an extension of 16.1. But look at Maratha judgment. Why this change? That brings me to the question of constitutional culture, on which we have not researched enough. Everyone knows culture is a creative source of claim making. What kind of researches we have done on 29? Nothing beyond 29.2's relationship with 30 clause 1. 29.2 says no one shall be denied admission in this institution on the basis of XYZ grounds. 31 says minorities based on religion and language shall have a right to establish and administer educational institutions of their choice. Even though in the Kerala Education Bill, Justice Das has already clarified it, but we had to wait till St. Stephen's and then TMFI. But that's all we have done on Article 29. We have not looked at right to culture. I believe cultural studies of law would help us to challenge traditional ideas of culture. It may help us to advance a new conception of law, a conception that examines law as a world of images, the power of which is not located primarily in the representation of something exterior to the image, but is found in the image itself. What is legal culture? Legal culture simply means ideas, attitudes, values, opinions, expectations that people have with regard to law and legal system. Do we do research on what are people's expectations of law? The legal culture must be an essential formative element of law. Has our constitutional culture been influenced by constitutional traditions in other countries, say Britain or United States, from where we borrowed a great deal? You will have some researches. Fundamental rights, civil liberties in India, USA, directive principles in India, in Ireland. But I think the time has come when we should research that while we did adopt several provisions from these countries, what about adoption of constitutional culture? How come we don't have a Black Lives Matter like movement against Dalit atrocities or mob lynching? I think we should have Dalit Lives Matter or Minority Lives Matter movement in India. What is the missing link? Even Brazil had a movement about living constitutions. Do we have any constitutional culture? If not, why? Is constitution just a document of power, not norms to be followed by the people? How come no research has been done? How far people have imbibed constitutional norms and values? How come constitutionalism is an American habit, but is not an Indian habit? All kinds of, writings have been there in the West. Erosion of constitutionalism by Grimm, Twilight of constitutionalism, Dobler, Deconstitutionalization, Peters, Waning constitutionalism by Rasmussen, Death of constitutionalism. If 19th century had witnessed the death of God, 21st century is witnessing the death of constitutionalism. Why this death is happening? When I am talking of people not having constitutional values, we as a nation not having constitutional culture, I am not on fundamental duties. People should do their duties. I am not, with that classical ancient Hindu jurisprudence concept that the only right you have is the right to do your duty. Do your dharma. I am not on that. As a civil libertarian, I believe that we have not adopted that Austinian or positivist model of rights and duties being correlative in that sense. That there is no father without a son, or no wife without a husband, as no right without a duty, or no duty without a right. I'm not on that. I know fundamental duties are a sophisticated strategy of authoritarian leaders. That's why Mrs. Gandhi brought it during emergency. It was not there in the original constitution. We make so much of hue and cry about secularism and socialist brought in 1976 by the 42nd Amendment. By the same amendment, fundamental duties were brought in, but our entire focus is on duties, not on rights. True, if constitution is a social contract, there are two parties to it, state and people. We blame and can blame the state for denying equality. Do we practice equality? What are the researches, constitutional law researches on people's behavior towards equality? Why there are no researches on Article 17? You had two laws under 17, the Civil Rights Act of 1955, SC/ST Atrocities Act of 1988. Ruler Untouchability was a book written by Thorat and Ghanshyam. A study of 100 villages where untouchability is widespread even today. Dalit bridegroom still cannot ride a horse. Why constitutional law researches are not there on the matrimonial acts? How racist are our acts? Everyone wants a beautiful, pretty girl to marry. Recently, there was an ad by someone that she should also be vaccinated both doses. Lot of attraction was there to this ad, which was basically a fake ad. Someone wanted to popularize vaccination. Liberty, dignity of individual. What is our attitude towards them? Where is a constitutional law research on the dignity of individual and how various laws undermine this dignity of individual? How various policies undermine this dignity of individual? I think fraternity and secularism are not entirely state's burden. Fraternity is entirely people's burden. If you have mob lynching, farmers are in a strike, farmers are on a strike for 7 months. Recently, there was a mob lynching of a Muslim boy. 50,000 people now, COVID times. They gathered and protested in favor of the accused. If 11-year-old young boy Junaid is killed in a train compartment and people keep quiet, do not protest, do not try to protect him, I think it is an endorsement of this policy of hate. And I think people are equally guilty. I understand that in the concept of justice and liberty and equality and fraternity, there is an inevitable element of subjectivity. Of course, there is no inter se primacy or priority amongst these concepts. But where is the research? In terms of the progress we have made in last 70 years or so, where were we in 1950? Where are we today? Why we have not been successful? Today, measuring success on these goals, these subjective concepts, is possible in quantitative terms. Number of reports are there: Freedom House, VDAM, World Rule of Law Project. But these reports are not used in constitutional law researches because we talk of judgments and we talk of interpretation of constitutions. That's all. Let me flag another area, very important, but has not been given any importance whatsoever in constitutional law researches. Article 48 of the Constitution. Of course, it was a compromise. Ambedkar did this compromise. There were Muslim members in the Constituent Assembly who wanted prohibition of cow slaughter to come in Part 3 of the Constitution. Ambedkar put it in directive principles, talked of modernity, animal husbandry, this and that. You have 194 laws under Article 48. Where is the research on them? You have number of cases. Where is the research on them? Gandhi ji said, in India, no law can be made to ban cow slaughter. I do not doubt that Hindus are forbidden the slaughter of cows. I have been long pledged to serve the cow. But how can my religion also be the religion of the rest of the Indians? It will mean coercion against those Indians who are not Hindus. Same thing which Pakistan is doing. If you look at their blasphemy law, they want non-Muslims to have reverence for Quran, to believe in prophethood of Prophet Muhammad. I think this is absurd. D.N. Jha, great historian who recently passed away, wrote a whole book, Myth of Holy Cow. Through authentic evidence, he proves that Hindus have historically consumed beef across epochs. If you look at Hindu texts, later Hindu texts, cow killing is a minor sin, not a major offense. If you look at recent amendments in all the laws, be it Maharashtra, Gujarat, and recently February in Karnataka, life imprisonment. Can you believe it? Life imprisonment. So what we are doing is even against the Hindu scriptures and texts. The Supreme Court relied on a study which was commissioned by state government in Gujarat. Interesting. No research was done to this. The Supreme Court just accepted it because it was in the affidavit filed by the state of Gujarat. This is famous state of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat case of 2005. Let me read this one line. It is estimated that a bull or a bullock at every stage of life supplies 3,500 kg of dung and 2000 liters of urine, and whereas this quantity of dung can supply 5000 cubic feet of biogas, 80 metric ton of organic fertilizer, the urine can supply 2000 liters of pesticides, and the use of these products in farming increases the yield very substantially. The value of above contribution can be placed at 20,000 rupees a year to the owner. No basis of this statement. No scientific research done. No empirical research done. There was another report. National Commission on Cattle, Department of Animal Husbandry, Dairying and Fisheries 2002. वहां बोल दिया गाय का गोबर कोहनूर से ज्यादा भी कीमती है, और सुप्रीम कोर्ट के जजमेंट में है. Can you believe it? But there are no researches, constitutional law researches on this. Prime Minister is emphasizing LPG as a cooking fuel instead of dung cakes, trying to help rural women. But Justice Guman Malloda, who was president of Jansangh Rajasthan 1969-71 and then thrice elected on BJP ticket, was the author of this report, National Commission. So why do we pass all these laws under Article 48? 194 legislations in different stages at different points of time to do one, that we want to protect cattle. Have we succeeded? Are these laws able to protect cattle, protect cow? There is a livestock census which is done by the government every 5-7 years. What does it tell us? A general review of cattle census from 1951 to 2019 reveal that even though 90% of India, except few states like West Bengal or some northeast states, we do not prohibit, rest of them prohibit. You have cow slaughter laws in every state. So 90% of India banned cow, calf and bull slaughter. The cattle population in the country grew from 155 million to 192 million in 2019. Thus adding on an average 0.5 million cattle per year. Now compare it with buffalo. एक तो problem ये है कि in English there is only one word for both buffalo meat as well as cow meat. It is called beef. And many people who are just taking buffalo meat, they are beaten up or lynched because it is called beef. So cattle population 155 to 192, 0.5 million per year. Compare it with unprotected buffalo species. Their population grew from 43 million to 109 million. 150% increase. There is no protection, so to say. Of course, in some states, even buffalo is also now prohibited. But by and large, this is what it is. 150% increase for unprotected buffalo. And therefore, the hypothesis whether these cow slaughter laws do lead to the preservation of cows has to stand, debunked. So the RTI, I said I will tell you about a cabinet note. This is a cabinet note of Karnataka's 2021 Act, February 2021 Act. The justification in the cabinet note of this new, far more stringent law is that every year 2,38,296 cattle were being slaughtered as per cattle census of 2019. ये कैबिनेट नोट में लिखा है. The beauty is the cattle census does not mention number of slaughtered animals. कर लीजिए आप क्या कर सकते हैं. I give you another example. UP, which has the most stringent law. 2003 census, UP's cattle population was 49 lakhs with a male to female ratio of 33 to 100. In 2019 census, male cattle population, instead of showing any increase, dropped to 20.04 lakh and male female ratio 12 to 100. We are protecting bullock, and this is what it is, 12 to 100, which is the lowest in the country. Same story is there in Gujarat, in Maharashtra, in Madhya Pradesh. I think any research on Article 48 has to go to these laws, whether these laws really protect cows or they are just used so that society is polarized, votes are secured, and in a way they damage not only the interest of the farmers, but the interest of revered cows, because people no more are interested in having a cow. If we continue to have such kind of laws, cows may disappear in another 100 years or so. No one will own a cow. That brings me to another topic, citizenship. Citizenship was not until 2019 even taught in constitutional law courses in BA LLB. We used to start with constitutionalism, with the preamble, and go straight to Article 12 and then Article 13, and leave this Article 5 to 11 of the Constitution because it was not important. Because we believed everyone who is born in India gets Indian citizenship. Then we passed Citizenship Amendment Act. Then we said we will bring NRC. Then we said we are going to launch National Population Register. And citizenship suddenly has become a very, very important topic to research in constitutional law. If you do even just a cursory reading of Constituent Assembly debates on citizenship, whatever is being said today by the extreme right was said in the Constituent Assembly. If you read judgments on citizenship, you will find even Supreme Court judges calling people who are helpless refugees as vultures, calling people who are crossing border as aggression under Article 352. And our Supreme Court saying that though Article 21 is available even to foreigners, but their deportation does not mean violation of Article 21. Even International Court of Justice has said that in Myanmar, they have a genocide going on right now. These people, if they are pushed back into Myanmar, they face definite prosecution and killing and genocide. But a more closer study of 2003 rules, citizenship rules, tell you National Population Register is not there in the Parent Act. Even a traditional constitutional law, research would find that this rule has gone beyond the Parent Act. There is no mention whatsoever of National Population Register, either in the Census Act of 1948 or in the Citizenship Act of 1955 as amended. And that reminds me that there is a need to do research on rules framed under laws. After all, rules are law within the meaning of Article 13. We must study rules and regulations. I think even in terms of theory, there is one idea of citizenship, which is a vertical idea of state and citizen. But there is another horizontal view of citizenship. Citizenship is also an idea of mobilizing people for struggle for rights. What is citizens' contribution to civil liberties? How civil society movements, organizations like PUCL and PUDR and several others, have contributed to the realization of our constitutional vision and goals in terms of civil liberties has not been researched in law schools. CAA protests gave us this idea that people do work in tandem with each other to realize the common and shared aspirations. It also gave us an idea about people's right to be different in terms of race, ethnicity, or language, what we discussed in Article 29. But something else. I may be different from the majority. I may be a gay or a lesbian. Differentiated citizenship. I am different but equal. And the whole CAA movement also again proved, since Professor Dhanda is there, just like the disability movement, nothing about us without us. Don't impose a law on us which we don't want. Farmers are telling this. Agriculture is a state subject. How many researches we do in constitutional law on agriculture? There are not one or two, many laws. Somebody may just do a research on pith and substance, colorable legislation, this and that. I think there is a need now to look at the whole mandi structure. Whether the first sale of the farmers is sale. I think a constitutional law researcher must be interested in contract farming. Federalism has been researched in law schools. But where is the research on the governor's reports? More than 125 times 356 has been used. Very interesting, strange reports have been written by the governors. Very easy study. In 6 months, you can collect all the reports of the governors and analyze those reports, and you are ready with your research. Center-state relationship, formation of states. What happened in Kashmir may happen in Bengal. Two BJP MPs have demanded that North Bengal should become a union territory or a separate state. There is a study in constitutional law on state reorganization commission. And do we want now to reorganize our states? And what should be the basis of that research? Whether autonomy to states, Professor Dhanda, just 5 minutes. Autonomy to states will weaken the nation. I think the constitutional law researchers must also address the apprehensions of the people, must answer the propaganda, motivated propaganda. एक देश एक विधान, भारत बहुत मजबूत हो जाएगा if 370 is abrogated. In America, you have constitution for each state. More than 370 is there for each state. Is United States a weak nation? Georgia had 9 constitutions. Louisiana had 11 constitutions. Federalism does not weaken nation. What is happening on GST? We promised cooperative federalism, but we are in a state of over-centralization. I said I will refer to public interest litigation. In our enthusiasm to control executive, we have given too much of power to judges. And as a result, all procedural safeguards have disappeared. Someone must do a research how public interest litigation has put our procedural law upside down. Elections is an important topic of constitutional law. Supreme Court will not hear electoral bonds case, but nothing prevents a constitutional law researcher from looking at the role of money in election financing. From where they get money, of course, they will not tell you after this electoral bond thing. But at least you know that which party is getting what. Delimitation is an extremely important topic of constitutional law. For the entire country, the delimitation will be done in 2026 based on 2021. Now 2021 census we are not able to hold because of COVID, so maybe 2022 census. About Kashmir, we were saying Ek Desh Ek Vidhan. Why for Kashmir we want to rely on 2011 census? Why we want to have delimitation for them in 2021? What earlier delimitation exercises have done? Which constituency was bifurcated? How it was bifurcated? Why delimitation is a political exercise? And finally, on reservations, 6 commissions prior to the non-statutory Rane Committee and prior to Gaikwad Commission said Marathas are forward community. Mandal refused them to include within BC. 2 BC commissions refused to consider them as backward. I think RSS chief was right when he said we need a debate on reservation. The only problem was he did not tell us on what subjects, on what areas we need a debate, what will be the topics of debate. I think the 11 parameters of backwardness given by Mandal Commission have become awkward. What were those parameters? Drinking water is beyond half a kilometer. Now you have a pipe water. Children between 5 to 15 years never attended a school. You have made substantive improvement in terms of enrollment. Dropout rates in this age group. Participation of female at work is more than 25% of state average. Can you believe it? If women are working, that means that community is backward. I think there is a need to relook at these parameters of backwardness. What castes are covered? Same caste of one community will get SC status, other community will get BC status. I think we need to come up with some new kind of index of deprivations. Similarly, on Article 30, so much is talked about, but do we really know how many minority institutions are there? Recently, the Gujarat government came up with a new law which took away the entire autonomy of minority institutions. And now numbers are available for Gujarat. So they have about 300 religious minority institutions, 97 linguistic minority institutions. These include 173 Muslim, 89 Christian, 10 Parsi, 25 Jain. And Jain, as per Article 25, are Hindus. 2 Jews, very interesting. 1 Sikh. Then in terms of linguistic minority category, they have 71 Hindi schools, not managed by minorities, 13 Sindhi, 10 Marathi, 1 Tamil, 1 Urdu, 1 Malayalam. We think minority institution protection under Article 30 is all about, Christians and Muslims. This is not so. And finally, I would say, we have not studied enough about union territories. Of course, you got a Supreme Court judgment, LG versus Delhi government, and a recent amendment about Delhi that LG means government of NCT, which is, I think, absolutely absurd. But what is going on in Lakshadweep? Their fertility rate is below the national rate, below the replacement rate, and we are coming up with a population control law. They are unlike Maldives, different kind of islands. They don't have cattle, they don't have goats, and we are coming up with a law controlling beef and this and that. I think there is a need to look at the administrative structure of union territories and see whether it is compatible with our constitutional vision. I think I will stop here because Professor Dhanda is not going to give me any more time. So I think these were broadly some of the areas I can think of on which bright people like you can do research. Thank you very much.
It's going to be your time even here, from here. It's just that it gives all of them an opportunity to also have a one-to-one conversation with you. So the only thing I want you all to process, see, the entire exposition from Professor Mustafa gave you a whole range of why questions in constitutional law. He was saying that, all right, if this has happened, what you need to ask is, why has it happened? Don't just be saying that this has happened. Don't do the what question, do the why question. The other thing also, which he has very admirably demonstrated, is he's saying that, all right, you look at Constitution, you don't just look at the Constitution, look at facts and figures, whether it was in relation to the entire exposition he did on Article 48 and the way in which, what has it done to the cow economy of the country? What is the relationship between Article 48 and the legislations which have been enacted by various state governments? I mean, that connection, and then to actually come to a point, I mean, it's a that, if you carry on with this so-called cow protection, you may actually oust the cow as an animal. You may really find that 100 years from now, the cow doesn't anymore exist. It's the kind of joining of dots which has been done, which is absolutely fascinating. And that's not how ordinarily we do constitutional law or constitutional law research. So the point where we've titled this particular workshop as Exploring New Frontiers in Constitutional Law Research. And I think Professor Mustafa has given you innumerable number of examples, and I'm certain that as you ask him questions, he'd be giving you further kind of details. But it's not to borrow a leaf from his. It's not like when I was doing the sort of abstract thing. He's given you solid nuts and bolts stuff on what is possible and what are the kind of questions we need to ask in constitutional law. So like yesterday, we're going to give you about 5 minutes pondering time. And then you start typing in your questions into the chat box. Professor Vasanthi will moderate the discussion, and we'll sort of see to it that you can have this one-on-one conversation with Professor Mustafa. I know a large number of you, when you put in your recipes, your one big reason was just an opportunity of interacting with him. So we are not going to deny you that opportunity. We are conscious of the fact that he's our university superstar. And so we will give you that opportunity and give you 5-7 minutes to think it through. And then you can start typing in your questions. And Professor Vasanthi, you can take over from here. Thank you so much.
Yes, I think we've had a lot of things to talk about. And like yesterday, I think it's useful to give people a chance to think about the questions and not kind of shoot straight off. So we will give you 5 minutes. Please type in your questions and we will make sure that all the questions are answered. So don't hesitate that, maybe we won't have time or, my question is not being asked. We will make sure that all the questions are read and asked. But we will take them together. So please type out your questions and we will take them all together in 5 minutes. I'm just taking down the questions as they're coming.
Yeah, he's back.
Awesome.
Jeez.
So we have an initial set of questions.
Let me also go to chat.
So it's okay, sir. I will read them for you.
Okay.
Because
we're trying to divide work. So what Vasanthi will do is that she will combine those questions for you. Yesterday, I kept getting into this trouble. That way, you just address the questions. If you have to do both things, then it becomes a bit too much for the speaker.
Okay. Just 1 minute.
Because the questions will keep popping up, sir, and then as you're answering.
No, you get distracted, right?
Well, I kept giving Vasanthi a lot of trouble yesterday, but I'm
hoping questions so it's easier for you to answer them.
Yeah.
Chale.
So the first set of questions are about, of course, since you have given very specific topics also, so they want to ask about specific topics like religious freedoms and conversion. And the question is, how does one frame these questions so that the research becomes more interesting? But I think another allied question is, while the topic may seem very interesting, the question is, how does one get the material? Like, for example, when you said that you can talk about the PMO office, information about these kinds of decisions might not be available. So the how question, so you've given all the why questions and why these are interesting, but maybe you could address also, how does one, frame the question, what kind of materials one can look at, and how does one do this kind of research?
When we used to do research, we used to manually, just 1 minute. यार क्लास में है, मैं बाद में करूंगा आपसे बात. Hello. Am I audible?
Yes, sir. Yes, sir. Please go ahead.
So when we used to do research, we used to manually search everything. So if I have to see what on my PhD topic is there in Harvard Law Review, I have to search manually all the volumes. So research has become very easy today. You can get all the material. There are materials which you can get under RTI from different ministries. If ministries deny you, then you can go in appeal. If your appeal is also denied, you can just send another appeal to the Central Information Commission. And most likely you will be able to get access even to files of different ministries. In fact, this is a new resource of research. What is there on the file? That was never a concern of earlier researchers because there was no access. You had an Official Secrets Act. You can't go near any file. But with RTI, getting material has become very, very easy. And then in terms of electronic resources, number of reports are now available online. So you can get them. Now, on freedom of religion, for instance, and conversion laws, I think we should also look at conversion laws of various princely states. In constitutional law research, you can also do researches on constitutional history. I didn't have much time, but for instance, how much of constitutional provisions of today were, say, adopted by the East India Company regulations? You will be surprised that number of good things which we subsequently incorporated in the Constitution. Forget about post 1858 direct rule of the British Crown. Even East India Company regulations incorporated several provisions of rule of law, etc. So similarly on conversion, now you have 8-9 states which have passed anti-conversion laws. These laws are easily available on net. You can also access the anti-conversion laws of number of princely states. And then what you should try to do to look at conviction of people under these laws. Recently, again, Gujarat and UP, Himachal, they have come up with new amendments, including love jihad in their conversion laws. Curiously, all these conversion laws are called freedom of religion laws, and they curtail freedom of religion. All these laws prohibit conversion but don't prohibit reconversion to Hinduism. Reconversion or ghar wapsi is also conversion. There are Supreme Court judgments on this. I think conversion and freedom of religion is one subject where a lot is available. I think you can do an interesting research on this whole doctrine of essentiality to see how a religious practice can be called as essential or non-essential. So earlier Supreme Court was saying they will look at scriptures. Now they say any superstitious thing or any irrational thing they will not permit. All religions are about, sorry to say so, a lot of irrationality. Religions are not about rationality. So I don't think that freedom of religion conversion is a difficult topic to research. One more topic, I think, which has not been researched enough. And again, this will also help the society. Large number of people today believe that Hindu temples are under the control of the state. while Muslim waqfs are not under the control of the state. So basically, you would say that this Hindu religious and charitable endowment acts, which initially was passed in Madras and then you have in number of other states, no one has studied them. The same kind of control you have for Hindu institutions is also there for about Waqf institutions. There is a Waqf board, here there is a temple board. In any case, the myth is that the board becomes the owner of the property of the deity, but that is never there, because the property ownership remains with the deity. Since in Hindu temples there is so much of cash and jewelry and money, there were chances of corruption. That's why, in 19th century itself, from Madras, a demand was made for the state control. So your article in the constitution says when a state takes over the property, it will be for a limited period. Now that is the article cited. Hindu khatre mein hai, Hinduon ki property pe qabza ho raha hai. The point is that this law is about any law made by the state. So many cases have been decided by various high courts and supreme courts on the Hindu temple boards, but I think it will be an interesting subject to research because it is very clearly a subject under Article 26.
Sir, another question that comes up, which came up yesterday also, is that how does one make this distinction between being an activist and a researcher? And many questions, you will have people when you don't have vice chancellors like yourself who will say, why are you taking up a topic that seems very politically motivated? So how do you strike that balance between activism and research, if you would like to say so?
Constitutional law is all about politics. You cannot do constitutional law without politics. Say if Supreme Court decides that electoral bonds are unconstitutional, it will favor opposition, go against BJP. If Supreme Court decides CAA is constitutional, it will favor BJP, will go against opposition. All questions, SR Bomai, challenge to imposition of precedent rule, political question. Supreme Court is the final arbiter of all political questions. It is a political institution. I think if any vice chancellor or dean feels that constitutional law researches can be done without looking at the wider political angle to it, no good research is possible without. Then otherwise you just read the judgment and read the text of the constitution. You do that kind of research, but that is all we have been doing all through.
The other question is about interdisciplinarity, sir. I think that's something that you have covered, and since you always said you're a student of history as well, and that really helps you when you're looking at constitutional law. So if you want to say something about how interdisciplinarity is very essential to constitutional law research.
Now you have to look at how institutions evolve over time. You say, look at the institution of the governor. I always say that the Mughal and Delhi Sultanate governors were all rebels against the central authority. All these principalities, say the state of Hyderabad or state of Murshidabad, of Sirajuddaulah and others, or Awadh of Shujauddaulah, all these, or the 5 Muslim kingdoms which came in South, Golconda and Khandesh and etc. They were all, revolting against the central authority. So traditionally, historically speaking, our governors were far more independent, asserting their power. The British governors were loyal servants of the empire. Unfortunately, when we drafted our constitution, the original draft was that the governor will be elected by the people of the state. Then it was said that, well, you have an elected CM, an elected governor, both will assert power, so how to resolve it? Then it was suggested that let us have an election by the state assembly. Then that idea was also rejected, and eventually now governors hold office during the pleasure of the president. Even though Supreme Court, I think in Raghu Tilak case, has said that the governor is not an employee, he is a constitutional authority. But fact of the matter is that a civil servant has a greater protection. I cannot throw out even a peon out of university without following the due process. But any governor can be removed, in a minute. So that's how it is. So anyone who is doing a research on governor's report, as I indicated, that is a good topic of research, should look at the institution of governors, in different periods of time. And then only you will be able to make a good research of what they are doing today and how they are behaving. So I think doing social science, be it history or sociology or political science, definitely helps. And that's why I very strongly advocated that look at law as a liberal art. So this whole contribution which was made by the positivists, that law is a separate discipline, different from morality and ethics and this and that, I think this has become a dated thing. We would have been definitely better off as part of liberal arts. Of course, legal reasoning is different, but legal reasoning also has something to do with the other social sciences and humanities. I am talking of integration of knowledge rather than the interdisciplinary approach. I don't see history or political science as different from my discipline. I see we are all part of the same universe of knowledge.
The other question that has come up, sir, is about the utility of comparative law. Should all constitutional law research essentially be comparative, or how does one do comparative? When is comparative relevant and when it is not relevant?
No, it depends what you want to do. For instance, if you are working on federalism, then you must compare yourself with Nigeria. I think African constitutions are one system which we have ignored in India. Latin America is another. Some of the Arab constitutions should also be compared now with modern constitutional systems. So comparative research does help. As I said, that if similar problem arise at a same time in different countries, then generally similar solutions are found. But it is not necessary. If you are doing a habeas corpus research, you may not look at any other country. If you are able to find 500 orders of habeas corpus, 500 petitions, that will produce a good enough research.
The other question that has come up, sir, is about sometimes topics tend to be very broad. For example, if you're looking at, and this is a question that comes up about the link between judicial administration and judicial independence. Now, are these like two broad areas, or is it still worthwhile to?
No, it should not be given. I think it is a problem of the supervisor and the research board. Professor Dhanda will never approve such a topic. I think it is better to have a very, very narrow focus for your research. You are not in LLB writing a LLB project. So this is not a good topic of research.
How does one narrow down those kind of topics? So very broad topics about judicial.
No, if you have done the survey of literature, you will know what should be your topic because you know what others have done. What we are doing in most universities, we are asking people to write a research proposal first, and then they do the research. Why we change our process and we take time in approving the research proposal? Because you first study that topic and then precisely locate what you want to do.
if I could just add, see, both judicial independence as well as when you talk in terms of activism, what is being suggested to you is that you can take those broad rubrics, but find a very specific example by which you are going to examine independence and activism. If you want to look at the generic things, then it becomes too huge. But if you are guided by independence and activism, but you are examining a more specific explication of both or exemplification of both, then it's something which becomes manageable for you. I think that's a point which Professor Mustafa really I think very effectively demonstrated, that it's you need to, these are the examples, this is how you can be doing it. But if you just go right back and say very broad topics, naturally you can't do a PhD on judicial independence and judicial activism. It's like a, it's a lifetime work, and still you may not finish it. And more importantly, the point that we were making yesterday, that like you'll accumulate a whole range of literature and you won't know what to do with it. So the point which was being made is, pick up a small topic and connect it to the larger issues. So the larger, you will latch on to the larger issues, and they'll give you some level of analytical rigor. At the same time, the work remains manageable. We're giving you pragmatic advice. We're kind of doing it both ways, that it's like that, okay, this work is worthy doing, but how can you do it effectively?
The other question is about drawing questions which are not obviously related, and how do we draw the connections? It's a very interesting question about can we look at adoption laws and look at it from the UCC, or is it like this is also JJ, right? I mean, and she's given a specific context of a child born to an unwed mother and those kind of issues. So how do we draw connections between areas which seem disparate? And that would be a very
No, you see, the general law is the JJ Act. So whatever JJ Act says, it would prevail over whatever personal law provisions may lay down. But if you are doing a research on adoption, it would be impossible to do a research without looking at Hindu law of adoption and adoption under personal laws. So try to study. That will also help you how we reached at this stage of JJ, why we rejected the earlier notions of adoption and earlier laws of adoption and adopted a progressive, child-friendly law with child as the center of our law. I think that journey is to be traveled to appreciate even the JJ Act. Interest of the child getting the primacy over anything else.
But if we, I think the dilemma is also that sometimes personal law can, if it is posed as a JJ versus personal law kind of a question, then
no, for a researcher anything is possible. There is no politics for JJ, politics for a researcher. He is just studying. So I think. If there is a conflict, there is a conflict. He will point out this is a conflict, it should be resolved. The researchers should also help the policy makers and the legislators.
So I think yesterday we spoke about the fact that how almost every area of law is touched by constitutional law. So there is that element that will go there. But obviously everything is not constitutional law research. So how does one strike a balance there?
No, constitutional law is the supreme law of land. It is the a compact between people and the state. So our broad vision is there in constitutional law, but there may be researches where one may not do intensive research of the constitution. For instance, if someone is doing some research about neighboring rights in IPR, then very little constitution they have to do, isn't so? Artistic freedom will come there, but I don't think that will require too much of a study of the constitution.
I think a lot of students struggle with this idea that I need to kind of try to put my research into one field, and you're asked to kind of label it. And sometimes that label may be difficult, isn't it?
We shouldn't try to label any research. Researches are not that it is in constitutional law. That is your LLM specialization. You are done with it. Once you are doing research, I think you have to, as I said, integration of knowledge. So that's why, it is the topic which is mentioned rather than it is a PhD in constitutional law or PhD in intellectual property or criminal law.
So I think we have a candidate who's saying that you haven't fully answered the question about activism and research. So I will read out the question.
No, I know the question. Let me give more details. I think good researches in areas where activists are working are not possible without relying on their work. For instance, if you are looking at displacement of people because of big dams, I think it is impossible to do such researches unless you look at the work which have been done by people like Nida Patkar and other activists. Activists, or today liberals, or who are now called urban Naxals, are not outcasts. These are the people who are on the ground, who have spent a lifetime there. I think our researches will get enriched and we should benefit by their experience. And therefore, I would very strongly say that whatever work activists are doing, if that has relevance to your research, we must speak to those activists and must study their work.
I think, Burhan, this was a question you asked yesterday also. And what we were, and your problem, I mean, one dimension Professor Mustafa has responded to, but the other dimension is whether the researcher himself or herself can be an activist. He is
why not? It is your choice.
Going back to that conventional thing of that we are meant to be objective. I think what one was telling you yesterday also, and this is just a reiteration on your part, is that you can be an activist in the choice in your political position and yet be objective in how you process the material which you have on you.
Right, true.
So I'm not really comprehending your insistence on this, because
let me take another example.
Yeah.
For example, if you are an activist working for prisoners' rights, I picked up that example, how the law evolved over the decades on this. Now, when you are doing your PhD also on prisoners' rights, then you cannot just say that your view is the correct view. So you can do advocacy for the rights of prisoners as your activism. But when you are producing a PhD on the prisoners' rights, then whatever you are saying, that should be based on solid evidence. So retain your objectivity as a researcher, and whatever subjectivity you want to have as an activist, want to fight for their rights, then you are free to do it.
Yes, so that's really true, because sometimes we end up thinking that a PhD thesis is like a lawyer's argument, only one-sided. It should be more in terms of taking all sides into the picture.
No, in any case, Burhan, no research is value-free. So in many researches, if you are an activist working for prisoners' rights, ultimate product may be what you want, but to reach there, mere activism will not help. You should come up with solid evidence.
I think we should little bit reiterate this point of this very great fear of taking positions and believing that because I have taken a position, my research is colored by it, and hence only if I'm not taking a position am I being objective. the point somewhere is this: none of us is a tabula rasa. We all kind of are created by our circumstances, our status, our society, all of that. So when you don't take a position, you still take a position. But you do it there, you do it unconsciously, and because you do it unconsciously, you believe it is objective. The point that is being made is declare your position and then kind of constantly interrogate it. Look at your materials and the fact, be conscious of the fact that this is my position. Am I being colored by it? If you are consciously reflecting on the fact of whether you are being colored by it or not, the chances of your reaching objectivity of a more robust kind is greater than when you are pretending that, oh, because you have not taken a position, you are being objective. Because actually speaking, Burhan, we are almost all of us, we are tutored into taking positions because of in the society we are born in, the community we live in, all of that kinds of feeds into us. It's like for a lot of us, we have, what should I say, de-educated ourselves and said, no, this is what society is telling me I have to do as a woman. I don't have to do that. It's a similar kind of thing that we are trying to say, and to honestly admit to a position is a greater guarantee of doing solid objective research than to pretend you don't have a position because you're trying to be objective, because actually you're not being objective even there.
And sometimes it's not so much as a pretense of not having a position as much as a blindness, which is even worse. That you are not even aware that you're coming into a particular position, and you are definitely, at least that consciousness is something.
I believe as a citizen we should take positions.
So we do take position.
As a researcher, we should take position after completing the research.
The thing is, sometimes we're not even conscious of our positions. That's the bigger danger.
No, I think Burhan, are you from Kashmir?
Yes, sir.
Yes. So that is his dilemma. Should I say that central government was unjust or not say so? That is his problem.
So then the other question that automatically follows this, that you have a position, but your guide does not have the same position. So how do we deal with differences between the supervisor and the candidate? Because sometimes we don't let supervisors
learn art of negotiation. If he is a good guide, he will agree with you. It's not necessary both of them should be on the same page, but any good guide would get convinced by your arguments. It's your thesis. It is not his thesis. It's your ownership. But it is better that you have discussions with your guide and he at least does not oppose your position, because I know many people could not complete their PhD thesis because they fought their guides. So don't quarrel with your guide. Persuade him so that he at least signs your certificate.
The other question is about the process of collection of data, and how does one, have effective data collection for a good research?
This depends. What is your topic? I think any good researcher should also talk to people in statistics or in quantitative techniques, and then decide what kind of data is to be collected and how it is to be analyzed. That's why it is important that we are not doing research on our own. We talk to people in other disciplines who have expertise in collection of data, in analyzing data, and that's how all of us have done it. Over. You have any more questions, Vasanti?
Yes, sir. There was like one general question linked to what we were doing yesterday, and Burhan had raised it right at the beginning. that if we are all talking about, how PhDs are just about becoming a degree, what needs to be done to restore value and essence to a PhD?
We are not in UGC.
No, sir. I think
No, no.
students have to
What can
restore
we
value.
do? You see, the point is, if we have reduced PhD to a class 10th certificate, that means that our higher education is in problem. I feel that we should not have PhD compulsory even for becoming associate professor. If somebody can write 3 good papers, that should be good enough for PhD. I'm not for this degree business. Ideally, one should feel like doing it. Nothing can be, compulsorily imposed, including vaccination. Professor Dhanda picked up that example yesterday. So I picked up another example, that a prisoner forced to go for Sunday service to a church. I think ये खुशी खां का सौदा है, that people should feel that urge that I want to work on this. They should have all the time in the world to do that research. So we should not, this many marks for this and that many marks for that. This whole quantification business of academic scores which UGC has brought in, I'm absolutely against it. If you are passionate about your PhD topic, then you will not feel like this. So pick up a topic about which you are passionate.
So that's all in terms of people who put out questions. So should we
can have a 10 minutes open house sort of thing, where people, if you have something you still want to ask, we have about 10-12 minutes there, so you can ask that, because people sometimes overawed by. So if you want to just switch on your microphone and ask that question directly from Professor Mustafa, please go ahead. I would just say that, if you look at all that he gave us in his exposition today, is that he did this back and forth between not just saying that, all right, you need to have a lot of how and why questions in what you determine to be your PhD topic. He also gave you a lot of examples of what this kind of topic could be. He also gave you examples of areas in which research is needed but has not happened. So if you pick up from there something which interests you, then I think the purpose for which these workshops have been organized kind of gets fulfilled. But we give you this last 10-12 minutes. If anybody has a last pressing question you want to ask, you can switch on your microphone and go ahead and ask it. Otherwise, we'll round off the...
Hello, sir.
Yeah, go ahead.
Yes, sir. So, sir, one of my concerns is that, as you said, that if you are interested in a topic, then you can have all the time to do research on it. But my concern with regard to constitutional law is that I don't know, because maybe I'm young, I want some kind of result or incentive. Like if I'm investing my 3 or 4 years in a research, where do I see the result? Because in context of constitutional law, all the changes are going to be made either in the constitution through amendments or by some judgment of the court. So apart from the academic work in which I'm going to add my research, apart from that, how is it going to impact society or have some other significance? I mean, if I want my work to be seen or have some, supposedly, if I give some solutions to an issue, how are they going to be actually implemented?
No, it's not clear what you are asking. Anything today you write or any work you do, it will get noticed. Somebody will read it. It will make some impact. Nothing, goes unnoticed today. So change may not come in today or tomorrow, but someone will read it and someone will take note of it.
Yes, sir. That was my only concern.
See,
But
Monica, it's like also, I mean, just to add on to what Professor Mustafa is saying, we can't, when we do our PhD researches, we can't at once put ourselves in the shoes of the policymaker and say, because I spent 4 years of my life doing this, so from here onwards, now, this and that should alter. I think that's like being, if I was to say, quote unquote, a little presumptuous. But what you can be saying is, if you have turned in, and that's the point he's making, if you have turned in quality work, if what you are saying is worthwhile, if that gets, like, you then put it out into the world, you disseminate it, you publish it, and that question that you have raised concerns other people. That was the point I was making, is that you choose what you choose as your area of research is something you are passionate about, but it starts having value for the world at large when you are answering a question that is concerning them. So in your choosing of your topic, in what you do with it, you have to persuade that many people that what you are saying is worthwhile. I mean, I think that's the point, whereas to straight off say, I think when we were saying we are in a post-Foucauldian world, one of the things that we all have got from Foucault is that power is not only present in the sovereign. Power is a more circulatory kind of process, and all of us possess it. If we disown our own power, believing that, I can't really do anything, hence I should do something, which if nobody notices, I'm okay with it. In fact, it should be the other way around. Do the kind of work which people will be compelled to notice. And don't be, therein taking a more, kind of Nishkam Karam kind of line, that you are doing it because that's what is your duty to do good work. What kind of value it gets or doesn't get, so many things can influence it. Not just because you're doing constitutional law, it could happen for any area of law.
I will give two examples.
Yeah.
93, 94, when I was working on copyright, I never thought that 1995 amendment in copyright will incorporate those things. So sometime you are lucky. It was not a path-breaking research. You just compared XYZ laws and you said this should be given, and computer software should be given protection as literary work and not as patent, etc. And since it was an age of liberalization, new amendments were undertaken. So many things which I said, legislators incorporated them. Now, when I'm writing on 370, it looks like it will never be accepted, but there is nothing impossible. Last year, people, or in 2019, people who were, called this gang, anti-national, put in detention. We saw 2 days before, the Prime Minister himself is having, snacks with them and having a conversation. So strange things happen. You do your work. Maybe, there will be a time that the legislators or judges will notice it, and you would be able to contribute to the change in law.
Food for thought. And possibly we can, all of us can very warmly thank Professor Mustafa for a very, very fascinating session, and Professor Vasanthi for moderating it so very effectively as ever. And I look forward to seeing many of you possibly in the next week's workshop. Thank you so much.
Thank you so much.